Hello, and welcome to our very first legal briefing here at Lomond Legal. I'm calling it a briefing because this isn't a webinar and it's not quite a podcast either. What it is practical information delivered in a way that feels accessible, straight talking, and hopefully useful. Now, full transparency. I'm not someone who loves being on camera or hearing my own voice in playback. If I had to choose between speaking to a room of 600 people or watching myself on screen, I'd honestly pick the live audience every time. But what matters most is getting good information to people who need it without fluff, jargon, or performance. So this format feels like the right compromise to kick things off. No filters, just insight that hopefully you can use. Now, Lomond Legal, we're new to the scene, but we're here for a reason, to make employment law more usable, more human, and more valuable for the people actually running businesses. We're starting with a topic called HR versus legal for a reason, and that's because in our experience, this is where most employment issues begin. As we grow, we'll be introducing a variety of ways to stay connected, some live, some in person, but a lot is most likely to be online, including this particular format. A little bit about business. Lomond Legal, we're here to help businesses stay out of court and keep legal costs under control with a simple and modern solution. At the heart of this is Rory, our all-inclusive fixed fee legal and HR support service. With Rory, employers get unlimited advice, legal representation, and zero deductibles. And that representation is extended even if a lawsuit happens. Our goal is simple, to give you access to information. Hopefully, you will see that our communications are designed to make employment law less intimidating, more proactive, and far more practical. I'm Julie, your legal sidekick today, and I'm here to help guide you through the evolving landscape of workplace risk. If at any point you have questions about anything you hear or see, just drop us an email at contact@lomondlegal.com and we'll pick up the conversation from there. Now, I'm going to start with the elephant in the room, and I say that because I know that plenty of HR and legal professionals won't necessarily agree with me on this. I also say this with full awareness, having started in HR myself before stepping fully into the world of litigation. I don't believe that HR and legal are two separate jobs. They used to be, but I don't think they are anymore, or at least they shouldn't be. HR doesn't just brush up against legal risk, it is legal risk. Every decision involving performance, pay, promotion, or discipline carries legal exposure. Now, that doesn't mean we should take the human out of human resources, but I think it does mean we need to recognise that legal is caught up and is now playing in the same space. In fact, legal is finally learning how to be human too. US employment law used to be literal. We had a black and white rule book you could work from confidently, and for a litigator, that was a dream. You could assess risk and clarity and consistency. But post-COVID, we've seen a cultural reset. Behaviour has changed, workplace norms have shifted, and yes, the legal system is trying to modernise to keep up, but let's be honest, not all of what we're seeing is progress. Some of it is chaotic, and worse still, it's unpredictable. As an employer, you're expected to navigate that chaos. And that's exactly why I say HR is no longer just about people. It's legal. Every policy, every conversation, every complaint, it all carries legal consequences. Courts are asking new questions. Was the decision fair? Was it reasonable? Could the employer have done more? And this shift brings a heavy burden for employers. At Lomond Legal, we've actually seen this movie before. In the UK, this environment where HR is fundamentally legal has been the norm for over a decade. Legal tests there aren't theoretical, they're lived, they're scrutinised, and they're litigated in workplaces daily. Now, I'm not saying UK law is the same as US law, because clearly it's not. But what is the same is the pattern. Employee rights expand, workplace conduct becomes more regulated, and employers are held to higher legal standards in how they manage people. We know the warning signs, the litigation triggers, and how to build policy and training that stands up to scrutiny. And we know, because we've been there, we've lived it, and we had to. So when I say we know what's coming, we really do. We do know how to respond to complaints, how to document, and how to create defensible practices. And it's not guesswork, it's experience. Let's look at some case law just to support and back up these changes that I'm talking about. In particular, Groff v. DeJoy, a USPS case that went to the Supreme Court. An employee asked not to work Sundays for religious reasons. USPS said they couldn't accommodate him due to scheduling challenges. And the lower court sided with USPS, but the Supreme Court is now reviewing it, questioning whether undue hardship really applies when you're a large employer with options. Now, the issue at hand was whether an employer must accommodate an employee's religious request not to work Sundays, and how far a company must go before claiming undue hardship. If we look at the background of the case, Groff, a Christian, worked as a rural mail carrier for the United States Postal Service. He refused to work Sundays due to his religious beliefs. USPS had a contract with Amazon requiring Sunday deliveries and began scheduling all carriers to work Sundays. And Groff requested accommodation to avoid Sunday shifts, and USPS initially tried to make informal arrangements, but eventually required him to work Sundays. And after missing multiple Sunday shifts, Groff was disciplined, and ultimately he resigned. He then sued USPS under Title VII of the Civil Rights Act, alleging religious discrimination. Now, as I said, the lower court sided with the USPS, saying that the requested accommodation, that is, not working Sundays, caused an undue hardship by burdening co-workers and disrupting operations. But when it reached the Supreme Court on the 29th of June 2023, the court unanimously clarified that employers must now prove that denying a religious accommodation would cause substantial increased costs in relation to the conduct of their particular business. Now, this replaces the old, lower, more than de minimis standard stemming from the 1977 Hardison case. The case was remanded to the Third Circuit to re-evaluate this under that heightened standard. But what does this actually mean for employers? Employers can no longer rely on vague operational inconvenience to deny requests. The burden now includes a specific financial or operational analysis demonstrating real significant impact. And factors now considered need to include employer size and costs, nature of accommodation, and the integration into business operations. And to further support that, there have been some early post-Groff cases, recent decisions, where they're already applying Groff's stricter standards. So the first case I want to discuss is Bordeaux v Lionsgate. Now, this was a case where an actress was denied a religious exemption from the COVID-19 vaccine mandate. Now, the court upheld the employer's decision, but only because Lionsgate was able to provide clear evidence that accommodating her would have resulted in approximately $300,000 in additional production costs. Smith v Atlantic City. This was a case where a firefighter, Mr. Smith, was a Muslim. And he was employed, obviously, by the City of Atlantic, or the City of Atlantic City. His faith required him to maintain a beard, but the fire department had a clean-shaven grooming policy for safety and uniformity, especially regarding respirator fit. Now, Smith requested a religious exemption from the no-beard policy. Now, the key issue was, did the city violate Title VII by refusing to provide a reasonable accommodation for Smith's religious practice? The court heard that the city did not violate Title VII, finding that the grooming policy served a legitimate safety concern. That safety concern was SCBA respirators must seal properly to the face. Granting an exemption would impose undue hardship on the employer, particularly in an emergency service context. So we can see that this case, that even under Title VII, employers don't have to accommodate religious practices if doing so would create a direct safety risk or undue hardship, especially in high-risk jobs like firefighting. A second case almost similar was Hebrew v Texas Department of Criminal Justice. Mr. Hebrew, a practicing Rastafarian, was employed by the Texas Department of Criminal Justice. We'll call it TDCJ. His faith required him to maintain dreadlocks and a beard. Now, TDCJ had grooming policies prohibiting beards for security and uniform appearance reasons. Now, the key issue was, did the refusal to allow Hebrew to keep his beard violate Title VII and the Religious Land Use and Institutional Persons Act? The court found in favour of TDC, ruling that the grooming policy was uniformly applied. The exemption would pose a security and operational burden, and under Title VII, the agency was not required to grant the accommodation. Now, this is hopeful to employers. Both these cases, and because they reinforce that uniform enforcement of grooming policies can be lawful if the employer can show legitimate operational concerns, even if it affects religious expressions. Now, what these cases actually demonstrate is that Groff isn't going away, and it is fundamentally shifting how Title VII is applied in the US. Title VII requires reasonable accommodation of religious practices, unless it causes undue hardship. Courts give significant deference to public safety, security or operational needs in uniformed services like firefighting or corrections. Employers need clear systems to document and evaluate actual costs or operational impacts when reviewing religious accommodation requests. An HR team should update policies, train staff, and start the interactive process early with real evidence, not assumptions. And these cases matter because it's signalling that shift in US employment law from strict policy-based interpretation to more flexible, human-centred review. Legal decisions now weigh reasonableness and effort to accommodate, not just policy language. Larger employers will face greater obligations because they're seen as more capable of adjusting schedules, shifting workloads, or absorbing minor burdens. And Groff isn't the only case reshaping employer obligations. Okay, so we have a reshaping of employer obligations with these changes in cases. Further ones we want to look at is Ames v Ohio Department of Youth Services. This particular case was decided on June the 5th, 2025. The court's ruling unanimously struck down the background circumstances rule that required majority group plaintiffs to provide additional evidence before moving forward with Title VII claims. In employer impact, that means employers can no longer argue that reverse discrimination claims need extra proof. Title VII protections now uniformly apply to everyone, lifting a procedural barrier formerly applied to certain plaintiffs. AMD Sales Inc. v Carrera, this was argued in November 2024 and decided in January 15th this year. The issue was the burden of proof. What is the burden of proof that employers need to show an employee is exempt from minimum wage and overtime under the FLSA? And the decision was the Supreme Court held employers need only meet the preponderance of the evidence standard, not the stricter, clear and convincing threshold. So this lowers litigation hurdles for employers in wage and hour misclassification cases. Employers now must simply show exemptions are more likely than not to apply, which is a measurable but manageable responsibility. Muldrow v City of St. Louis, this was decided on April 17th, 2024. And this held that even transfers that don't cause material harm can still qualify as adverse employment actions under Title VII. This means that employers must now treat more management decisions like transfers, demotions, reassignments as potentially actionable, even if the consequences seem minor. Reasonable care is essential. What these cases are showing are a clear trend and that the law is demanding more rigour and clarity from employers, not less. in both federal and state courts. Procedural shortcuts are gone, clear evidence is still required, but thresholds are clarified, and even small decisions are legally significant. So, when does legal need to step in? HR handles a huge amount from employee relations to culture, compliance, and day-to-day operations. They are the front line. But some situations carry legal implications so significant that handling them alone can put the business and the individuals involved at risk. It's not about HR falling short, it's about recognising that when legal scrutiny is inevitable and making sure you're prepared to defend, prepared to argue reasonableness, and prepared to justify decision making. These moments require collaboration, not isolation. Recognising when to escalate shows wisdom. It's how confident professionals protect business and people. I remember when I first became an HR director, that feeling that I had to know everything about everything, every policy, every regulation, every legal nonce. The weight of being the person who should know, it was heavy. But what made the difference for me was knowing I had someone to call, someone to check my thinking, ask a second opinion, or just confirm that I was right, or tell me if I was wrong. It wasn't about being capable, it was about being responsible enough to want certainty when it counted. And just because legal tests are broader now doesn't mean the expectation hasn't always been there. Even 30 years ago, HR was expected to understand legal risk and often to carry it alone. I grew in confidence by using the support I had, because no one knows everything, and anyone who says they do, they're either not being honest or they've stopped learning. Now, I'd like to walk through some of the most common employer slip-ups, the things that can trip businesses up, most often anyway, and more importantly, how to avoid them. So, examples being dismissing a complaint too soon. It didn't seem like a big deal is not a legal defence. If an employee feels harmed or disrespected, and you fail to take that seriously, the business is at risk. As an employer, you don't get to dictate how someone else feels. You may believe they're overreacting or holding an unjustified sense of grievance, but it's not your role to make that judgment without first establishing the facts. Even if you suspect the complaint lacks substance, you still have a duty to assess it fairly, objectively, and without bias. Because once you dismiss something too soon and without evidence, you're no longer managing risk, you're creating it. Poor documentation. You might have handled the issue perfectly, but if you don't document it, it never happened. I've seen employers lose cases they should easily have won, not because they acted unfairly, but because they couldn't prove what happened. No emails, no notes, no voice memos, not even a text message. No record of the conversation or decision-making process. Documentation is your safety net. It's a get-out-of-jail card, and without it, credibility is vulnerable, and the court or agency may assume the worst. Audit trails aren't just red tape, they're a defence strategy. Overlooking retaliation. Retaliation claims aren't about what you meant to do or say, they're about how your actions or work looks. If an employee raises a concern and soon after finds themselves excluded, passed over, or disciplined, even for a valid reason, that sequence of events can trigger a retaliation claim. Courts don't take these lightly. In fact, retaliation is one of the most frequently upheld claims in employment litigation, often because it's easier to prove than the original complaint. Even if the adverse action was justified, timing and tone matter. You must be able to show clear, non-retaliatory reasons, documented and consistent with past practice. When in doubt, pause, document, and consult, because the cost of being seen as punitive can far outweigh the original issue. Then we have untrained managers and misapplying policy, and these two can be individual on their own or together, because the best written policy in the world is useless if the people responsible for applying it don't actually understand it. Too often, employers are handed a handbook and expected to just know how to deal with complex issues, from accommodations and grievances to misconduct and mental health. But policy isn't common sense and HR isn't instinct. When managers act inconsistently or make decisions without proper context or training. They expose the business to risk, even if their intent was good. Consistency matters. Process matters. And that only happens when managers are trained, supported, and clear on how to put policy into action. Because when frontline decisions go wrong, it's not just a policy failure, it's a liability. Most legal claims don't start because of a bad policy. They start because of a bad decision made by someone who didn't understand how to follow it. Employees don't always experience HR directly. They mostly experience their manager. If that manager misapplies a rule, skips a step in a disciplinary process, or responds emotionally to a complaint, the legal risk skyrockets, and the court doesn't care what your policy says. It cares what your manager did. Now, HR doesn't need more pressure, it needs more partnership. And the truth is, a lot of what's landing in HR's inbox today comes with real legal weight. That doesn't mean HR should step aside. It means HR deserves backup. That's why we built Rory. Not to replace HR, but to stand beside it. To give legal clarity, coverage, and confidence when it matters most. If any of this sounds familiar, if you've ever hesitated on whether to escalate a complaint, if you've wondered whether your documentation would survive a tribunal or court, that's exactly why Lomond Legal exists. We offer exactly what modern HR teams need. Practical e-learning for managers and teams, fixed cost legal and HR support with no hourly bills and no deductibles, and most importantly, real people behind the platform, ready to step in when things get tough. This isn't legal as usual. It's legal the way modern HR needs it. And we can fix it together. If you've got any questions, need a second opinion, drop us a line. No pressure, no pitch. You can get us an email at contact@lomondlegal.com. If you found this helpful, our next discussion is going to focus on how to build defensible documentation from day one without it ever actually taking over your job. Now, I have provided the judgment links to the cases that we discussed. You may find them useful. And thank you for attending our presentation today.